Good evening, this is John Milburn, Laws 19038, Planning and Environment Law. This is week 6, and this week we're talking about planning law principles and assessments. There is a lot of material in your notes. Bates has a lot of material as well. You have 4 assessment problems to consider during this week, and of course on top of all of that we have the first assessment piece. I am going to speak about the first assessment piece, providing some degree of hint. I appreciate that 2 students have already submitted papers in draft form. I will contact those students, but just so you're aware, I don't mark draft papers, and my general rule is that if what you have submitted is in draft form at the due date, then I will mark that as the final assessment. Of course, if it's in draft form, for those students that have already submitted work, you can alter that, delete, change, update the material in final form up until the time that the assessment is due, which is Thursday, the 28th of April at 11:45 p.m. That is next week. Okay, so first hint. Let's think about the process of a development application being considered at first instance. So a typical application involving a planning and environment matter goes before an assessment manager, and the assessment manager is normally a counsel. The person who is making the assessment does so in a way of a merits review. In other words, to consider the matter from first principles and make a decision. So not so much a merits review, but rather just making an assessment. Now, once the assessment is made, the decision will either be approved without conditions, approved with conditions, or rejected. And it may be that someone, either the applicant, in the case of an approval with conditions or a rejection, or a submitter, in the case of an approval without conditions or an approval with conditions, may wish to object to that decision. And the appeal process is then, at first instance, to the Planning and Environment Court, typically, where the Planning and Environment Court judge makes a decision as a merits review, providing the best decision based on the material, and what we call undertaking the merits review so that the correct and preferable decision is made by the judge. That process means that all of the material is presented to the judge, who steps into the shoes, as it were, of the original decision maker to make the decision, and that's the whole basis of a merits review. So we know that we can look at the court's website, we can look at those matters where the decisions have been made, and I'll just go back to the court's website and share the page with you to explain this better. So we go to the court's website. You should see that now, and you can search the civil files. We did that last time, and that means searching civil files through a name search, etc. So I won't go through that process again, but you would have seen in that process examples of appeals to the Planning and Environment Court, which is a notice of appeal. What I want to talk about tonight is something a bit different, and that is a situation where we are applying to have the Court of Appeal consider the decision of the Planning and Environment Court to determine whether that decision was made according to law. So whereas the Planning and Environment Court judge makes a decision which is based on a merits review, a different regime entirely applies for an appeal to the Court of Appeal from the Planning and Environment Court. The first thing that you'll notice is that it is not a merits review. It's a review based on arguments of law, essentially asking the Court of Appeal to make a decision to the effect that the Planning and Environment Court got something wrong. But before you can get your foot in the door, so to speak, in the Court of Appeal, you need to seek leave to appeal. In other words, there's no as of right ability to appeal to the Court of Appeal. The Court of Appeal will only consider those matters that it regards as sufficiently important to, or of interest generally, to warrant the matter being heard by it in full. So let's have a look at the form first of all. We go to Queensland Courts forms. You'll see there's a whole range of different forms that relate to different areas of law. Adoption, bail, child protection, coroners. Well, none of those is what we're after here. Corporations, cremations, so on. Criminal practice, domestic violence, general, Justices Act, land court, it's not that, mental health, penalties and sentences. We're getting close now. We get down to the Uniform Civil Procedure Rules. Okay, this is where we need to look, and what we're looking at is the process, the mechanics, if you like, of getting a matter from the Planning and Environment Court to the Court of Appeal. So the Court of Appeal is in the Supreme Court. There are two divisions of the Supreme Court. One is the trial division, where the Supreme Court actually hears cases, and the other is the Court of Appeal, where the Supreme Court in the Court of Appeal actually determines whether another court has followed the law appropriately. So if we pan through the UCPR forms down to form number 69, you'll see that's an application to the Court of Appeal. And if we call up that Word document, it guides us in some way as to what it is that we need to think about in determining this question of appealing from the Planning and Environment Court to the Court of Appeal. So the first thing you'll notice is that it's a Court of Appeal which is a division of the Supreme Court of Queensland. The appellant is the party that wishes to appeal the decision of the Planning and Environment Court. The respondent is the other party. You'll see that the word first is there. What that means is that it's possible to have more than one respondent. You might have a first respondent, second respondent, third respondent, and so on. Now, this is an application to the Court of Appeal. It's not an appeal itself, but it's an application to the Court of Appeal for the following orders. So you need to set up what it is that you want. You need to refer to the judgment being appealed against, which is in the Planning and Environment Court. And then, importantly, you need to satisfy the preliminary question of applying for leave to appeal. As I said before, the Court of Appeal will only consider certain matters. You need to show good reason why the Court of Appeal should consider your particular matter. So in Part 3, you need to include the reasons justifying the granting of leave and set those out. When you read a case in the Planning and Environment Court, you should read it critically and ask yourself the question, if I had to appeal this decision, if someone came to me and said, I'm not happy with this decision, can you take it to the Court of Appeal? Well, firstly, you need to know the procedure, but secondly, you need to think about what would be appropriate reasons for justifying the grant of leave by the Court of Appeal. So things that you might want to consider are that in some way the learned judge in the Planning and Environment Court got it wrong. And that might be that the judge misapplied the law, got the law wrong, applied the wrong laws, didn't apply all of the appropriate laws, applied the right laws but did so with the wrong conclusion, gave too much weight to certain things, gave too little weight to certain things, ignored certain legal principles, for example, the precautionary principle or principles in relation to intergenerational equity, things of that nature, or did consider those but gave too much weight or too little weight, as the case may be. So when you're reading the decision, any decision in the Planning and Environment Court, you need to ask yourself these things critically and essentially, without being disrespectful, ask yourself the question, did the judge get it right? Was there some error in logic that would enable me to apply to the Court of Appeal for a different decision? So that's what we look for when we're talking about critically reading a case, not just reading it and being able to summarise it, but read it as if you had to challenge the decision in an appropriate and respectful manner. In the assessment that I have set, I do ask you to follow the appropriate referencing guidelines. That's the Australian Guide to Legal Citation. You'll see that there is a link to the AGLC admin Moodle, and it's a very complicated document in many ways, the Australian Guide to Legal Citation. It's reproduced in PDF format from the Melbourne University Law Review. But what I'd suggest is that you look towards the back and you'll see a quick reference guide to citation for some of the more commonly used materials in law studies. And that will help you in terms of your assessment. If you need to go beyond that, let me know. But what I'll do, and in fact I'll do this now, I'll cut and paste some material that might be of use to you. It's drawn from the University of Sydney Law Library Guide, and there's a link there so you can go to the full guide as well. And as we speak, I'll put that into UCrew. I'll just post that now. I'll pin it until tonight. And if you have any questions about that, please raise those questions through UCrew, as I encourage you to do always. So you'll see that there now. Okay, there's a lot of material in Bates. There's a lot of material in the weekly guide that I've provided to you. I've provided you with some summary of Bates, as I always do for the weekly session. So tonight, I want it to be a bit more practical. So I've already shown you some things about lodging appeals or application to seek leave to appeal in the Court of Appeal. What I want to do now is show you a really good website. It's the Queensland Government Department of Infrastructure, Local Government and Planning website. And I will share the screen. We'll do that now. So you should now see the website for the Department of Infrastructure, Local Government Planning. Now, the reason I want to show you this is it's got some excellent information and it's got some great information to assist you in the planning process. So firstly, if we look at infrastructure, you'll see some headings that are probably familiar to you. And the local government infrastructure headings are very useful. That provides some good commentary in relation to planning and policy. And over here, we've talked about COAG, the Council of Australian Governments, and that's very important in the context of federal and state cooperation. So there's some really good information there on COAG, and I'd urge you to have a look at that. Now, if we go at the bands across the top, I've mentioned briefly infrastructure. I'll now go to local government, and under the heading of local government, you'll see that there's information about laws, and I'd refer you to local government, local laws, which is delegated legislation, and it's to do with statutory instruments by local government. We talked about that last week, and it provides some information. It talks about the power of local governments, how they draw their power and what they can do. So some really good information there. Talks about drafting local laws and the legal process. It also has reference to the model local laws and local laws databases. So lots of really good interactive material that will help you understand the process of planning in Queensland. Now, speaking of planning, you'll see that one of the headings across the top is in fact planning. And again, there's a lot of useful information there. I'm going to refer you now to plan making and also to development assessment. Firstly, plan making, you'll see that we have information that is useful about state planning, statutory guidelines, regional planning, and it provides some valuable, useful information about the planning process and the planning hierarchy. Now, one section that I think is really excellent is this section here about development assessment. And what I want to show you particularly is the flowcharts. So let's have a look at development application steps. Click on that and you'll see here in the drop downs at the bottom, there's, oh, I'm all thumbs with this. You'll see here at the bottom information about, sorry, development assessment. I had it before and I've lost it. We'll get there, sorry. So development application steps. Perhaps if I go up this way. You've probably seen it already, it's just that I can't get to it. So development application steps, I'll try again, and flowcharts. So it's down here, that's right, so we'll get to it that way. So we'll go to flowcharts, and now you are required to answer a series of questions which will help to explain the process. Of course, you need to know what these terms mean in order to answer the questions sensibly. But one of the good things about the flowcharts is that it gives you an opportunity. So I'm just stopping the share for a moment. One of the great things about the flowcharts is it gives you an opportunity to actually think about the important terms and put the terms in context. So you need to understand the terms, you need to understand the procedures, and then this chart will provide you with great practical information about tying it all together. So I'm just going to share the screen again. So the first question is your proposal exempt development? Well, look, let's say no. That then triggers another question. Is your proposal self-assessable development? And again, we'll go no. So it then comes up with a statement. Your proposal involves assessable development and an application is required. Okay, so is the application referred to required to be publicly notified? Let's be optimistic and say no. Oh no, we'll say yes, it is required. That would be the usual situation. Will the application involve referral to an IDAS referral agency? Let's say yes. So a referral agency is perhaps a concurrent agency, for example. And is the application likely to involve an information request? Let's be optimistic and say no to that. So once we've completed that, we have the ability to show the flowchart, which we'll now do. And you'll see that the flowchart provides relevant information with respect to the steps, the application stage, the information referral stage, the notification stage, and the decision stage. And the thing I like about this flowchart is that these terms, these steps really comes to life now. It actually provides you with information about the process, the terms, the procedures, the order, and the days. So 10 business days, 20 business days, and it provides you with great information. So I'd urge you to look at that website, play around with that website, and perhaps learn from that the procedures that are required. If I go back to that page, I'll also refer you to development assessment processes generally, which is planning, development assessment process, and it has information about the compliance assessment, deemed approvals, self-assessable development, things that are really very useful. Have a look at this one, the State Assessment and Referral Agency, which is SARA. You'll see that acronym SARA quite a lot, S-A-R-A, and there it is there. So this is where the assessment which involves state matters is determined through that SARA process, the State Assessment and Referral Agency. Also, MIDAS is an online, there it is down the bottom, it's an online facility, and it provides you with an opportunity, as it says there, an online system that allows an applicant to prepare and lodge particular applications to the department, which may be SARA, where the state is the assessment manager, or a referral agency for a development application. So if you just have a look at that website, it will provide you with valuable information and hopefully tying together some of the information that we've been reading about. Just going up to the top under the heading of resources. I'm sorry. Just go have another look at dispute resolution sections. Where is that? Oh yeah, over here. Dispute resolution, the Planning and Environment Court, and that contains a link to practice directions and P&E court rules. That is very useful, as well as a website link back to the court's website. The other one that's there, the Building Dispute Resolution Committee, is a committee that hears perhaps certain low-risk technical disputes. That's worth having a look at as well. Now, up the top, we have the resources, some very interesting and valuable information there. I find that fact sheets are often very useful. And you'll see here some SARA templates and, importantly, some Sustainable Planning Act IDAS forms. And you would have read that IDAS is the Integrated Assessment Scheme or System. So have a look at those things, because it will provide you with some very practical information and hopefully put it all together. Okay, so I'll stop the share now. Last week we talked about delegated legislation, which is principally statutory instruments, and the Section 15 of the Sustainable Planning Act identifies what are the statutory state planning instruments and provides some idea of the hierarchy. So I'd urge you to have a look at that. Now, apart from that, and this is, I don't think it's really highlighted in the notes, there's some information in the website, on the Moodle page, about environmental searches. So if you are a person that's involved in advising a developer, or perhaps doing some conveyancing if you're in a law firm, then you may need to consider doing some environmental searches. For example, you should always undertake a search of the Environmental Protection Agency to see if there are certain issues that relate to contamination, and that will have a legal effect in terms of any application that is lodged in a planning in a planning context, or any conveyancing as well. Town planning certificates are also useful, and there are other issues to do with administrative notices, and some things cannot be the subject of a search, so I'd urge you to have a look at that. All right, have a look also at the State Development and Public Works Organisation Act 1971, and there are some things there that may affect the land and property, and that's under the state government prescribed projects. Now, that's something that you'll become very familiar with in the context of the second assessment piece. All right, so let's just go back to the website, Moodle. I'll share the screen once again, and you should now see Moodle up on the website. I'm interested to see if people have been providing certain responses to the weekly problems. So, as always, we look at last week's problems, and let's go down to week 5 in Moodle. Problem to do with sustainable development and good governance. So at this stage, unfortunately, we don't have any responses. But the question calls upon you to consider sustainability, talks about the aspirational goals, and it makes reference to a decision of Preston CJ and Hub Action Group against the Minister for Planning 2008 case. So in terms of that sort of question, bear in mind that there are some issues that you should consider generally, and that might be to do with the way in which things like sustainable development filters down from an international level to a national level, and the way in which courts interpret domestic law, and they do so in a way that favours compliance with international obligations. All right, so I'll leave that with you. We have the first assessment, which is due on the 28th of April. So that's next week at 11:45 p.m. And at this stage, I see that we have 2 submissions in draft. no one has submitted a formal assessment. So there's still plenty of time to do that, but I would hope that you are now well advanced in your progress for that first assessment piece. If you have any questions to do with the first assessment piece, please ask through UCrew. Bear in mind that I have to be very careful about the extent to which I can give hints or answers, and that will be certainly the case once people start to submit their work formally. My suggestion is, by all means, you could submit a draft, but I won't answer any draft or correct any drafts or consider them. But with your final, I would submit it, maybe a day or two before it's due, just in case you think of something new, or maybe there's something interesting on the UCrew website that you hadn't considered earlier. So if you submit a bit later, at least it gives you a chance to change something that you had in mind. All right, thank you very much for attending. All the best with your assessment piece, and we'll see you next week. Bye for now.